Hello, my name's Stewart. I'm a partner at Waterhouse, and I'm the author of Butterworths Data Security Law and Practice, the UK's first book on data security law. Since 2007, lawmakers in the United Kingdom have been building a new legal framework for data security. The reason why law is being built in this area is explained by the torrent of bad news stories about security breaches and data loss. Some of the biggest and most famous companies in this country, as well as major government departments and organs of state, have suffered serious data security incidents. And as a result of all the moral panic that's associated with these phenomena, lawmakers have been pushed forward in order to achieve ambitions of better data handling and data security for the UK. Now, prominent within this new legal framework for data security is the new financial penalty that came into force on the 6th of April 2010. This new financial penalty gives the Information Commissioner, the regulator for data protection, the power to issue fines of up to £500,000 on data controllers that suffer serious breaches of security. Now, in respect of the organisations who are liable to this fine, these can be government departments, other public authorities, any business working in the private sector, and of course any third sector organisation as well. And this financial penalty is bound to attract massive news headlines when the first fine is imposed. Now, unfortunately, most organisations in this country do not yet appreciate the full implications of the financial penalty. Most organisations, according to my research, are not prepared for this new legal environment, and consequently they are exposed to the massive risk of headline-grabbing news stories following a security breach and the imposition of a fine. This is a board-level issue. Directors of businesses and directors of government departments need to take it seriously. If they do so, there is still time available to organisations to put in place the necessary measures and controls to keep their organisations relatively safe from this new legal regime. So how does the financial penalty work? Well, if the Information Commissioner learns about a security breach or data loss, he'll conduct an investigation. And the first issue for the Commissioner is this: is the breach of security or data loss a serious problem? If it is a serious matter, then the legal regime is triggered. Now, a matter can be serious in many different ways. For example, losing a small amount of very, very sensitive data can be a serious matter. So can losing a huge amount of trivial data. That can be a serious matter. So along this spectrum of possibilities is the pitfall for any organisation that operates in this jurisdiction. So if the fine is serious, the next question, if the breach is serious, the next question for the Information Commissioner is whether or not the breach is one that can cause substantial damage or distress to the victims. Now, this is an important matter because what it tells us is that the Information Commissioner does not have to prove that financial loss or damage has been suffered by the victims. Mere distress, mere concern, worry and anxiety on behalf of the victims can be enough to trigger the imposition of the fine. And the final component that needs to be borne in mind is this: that the breach of security or the data loss must actually result from a deliberate act on behalf of the organisation involved, or the organisation must have been reckless. Now, I'll come to deliberate issues in a moment, but as far as recklessness is concerned, what the law says is this: firstly, did the organisation know, or should it have known, about the risk to security? If it did it know, or should it have known, that the risk was likely to cause substantial damage or distress? And if so, did it fail to take reasonable steps to prevent the security breach or data loss from occurring? Now, those are the legal issues within this new financial penalty. Now, as I said, the Information Commissioner can impose a fine where the breach is deliberate. Now, for many organisations, unfortunately, it will be possible to prove deliberate breaches. And the reason I say that is that it's my experience, having acted in many of these cases, that when you look at organisations after a security breach, you discover a considerable amount of evidence that shows that they have been warned of the problem. So, if your organisation has instructed consultants, if it's instructed lawyers, if it's instructed auditors to review data security, IT issues, then there's a distinct possibility that there will be smoking gun evidence within your organisation that leads to a conclusion or will enable a conclusion that the organisation has deliberately turned its back on the issues and has closed its mind to the need to take restorative measures. So in these circumstances, a deliberate breach can be proved, and of course a deliberate breach is an exceptionally serious event. So what should organisations do to make sure that they're on the right side of the law? Well, my message is clear and it's simple. If you understand how the law is framed, if you understand the resource constraints that the regulators face, and if you understand that the human nature of regulators is to take the path of least resistance, then you will understand that the first round of analysis in a security breach is a review of the security policies and the other documentation relating to data security and IT security. And this tells us that our organisation should try and build a proper set of rules and documentation that cover the security threats in the organisation. If they do that, and if they benchmark their rules against all of the legal requirements, and if they then conduct their operations in accordance with these rules, they will create a legal framework that is sufficient to avoid the financial penalty in many cases. And the reason I say that is because data security law within the Data Protection Act and in other places is not a no-fault regime. In other words, data security law allows organisations to suffer security breaches and data loss. You can make operational mistakes and failure without being in breach of the law. In other words, not every breach of security or every data loss is a breach of security law. When you understand these dynamics, you'll then understand the importance of focusing on your systems, your paperwork, your rules, your contracts for data security. You will embed these systems within your organisation and you will carry out checks to ensure that operationally they're followed on the ground in the course of everyday activity. And this is the route to legal compliance and ultimately the route to avoid this £500,000 fine. Now, we should not forget, of course, that within this legal framework there are many other components and elements to the building of new law. The fine is part of the penalties-based approach to lawmaking, but we also have a transparency-based approach to lawmaking too. What that means is that the law now requires organisations suffering security breaches or data loss to inform the Information Commissioner and of course the Financial Services Authority, if it's a financial services business, of the actual event itself. In doing that, of course, you equip the Information Commissioner and the FSA with the information they can use against you and from which they can impose their financial penalties. So in conclusion, have regard to your system for security, make sure it's embedded operationally, and have regard to where the law is going. If you don't, you're likely to be a news headline at some point in the future. Thank you very much.